Bruno?
Hey Nick, how are you?
I'm good and you.
Good, good.
Good. We're going to do a couple of questions today. So let's start off with two for you. The first one is we have a question from a viewer with just some guidance on how to deal with bad shareholders in terms of a company situation. Just some broad strokes on maybe some options that people can look at to handle bad shareholders.
So having bad shareholders or disputes with shareholders is a very common feature in South African business and internationally. And it's very important for a person entering into a business with somebody else to be aware of what remedies they have against those individuals if something were to go wrong. So in my commercial practice, the first thing that I always suggest to people before getting into business relationship with each other is to date, right? And now people don't listen to this advice and they go straight in, they don't think about things. And unfortunately, this is where the mistakes start happening. And I'll speak about those in a second. But you don't actually need to rely on these specific provisions in our law to get rid of bad shareholders if you just follow my advice from the beginning, which is prepare a proper commercial term sheet, right? All that means is that before you get into bed together with another business partner, write out the specific commercial terms that you guys believe exist in this deal. Why? Because sometimes you find that it's mismatched. One business partner thinks that they're going in one direction, meanwhile they're going in a completely opposite direction. So get these commercial terms down on paper. You can do this even without an attorney. Straight after that, go to the attorney and make sure that they draft the shareholders agreement and the MOI that basically reflects these terms that have now been agreed to. And you'll see as you go through these terms with the attorney, a proper attorney that knows how to do this will run you through certain scenarios and will test. They will stress test certain scenarios in order to try and ascertain whether there's sufficient protection in case a person needs to pull out or exit. Is there something that they can do to pull out and exit? And is there a quantification of an amount, for example, for the payment of the shares or a return of a contribution or whatever the case is? All of this can be managed in these agreements without having to rely on the legislation. But if you don't listen to me and you go ahead anyway and you take 50% shareholding in a company and you don't have any special MOI, you take the one straight from CIPC, no shareholders agreement, nothing in writing. There are certain provisions in our Companies Act that give assistance or that remedies certain issues that may arise. And these are the sections in about 162 to 165, in fact. But the ones I'm going to focus on today specifically is section 163 and section 164. Now, section 163 speaks about oppressive behavior by a shareholder. Now, it has to be oppressive, it has to be prejudicial, it has to be in disregard of another shareholder. And whether the shareholder is a director or a shareholder, if they treat their fellow shareholder, their business partner, in such a manner that falls within the scope of this particular section, there are ways to request the court for assistance to force them out of the business, especially when you don't have any other provisions that force an exit. This is one way of being able to approach the court to force an exit out of the business with respect to a shareholder that is being oppressive, prejudicial, disregarding the interests of the other shareholder. Now, this has a very broad meaning. And unfortunately, it's not a question of, well, he disagreed with me, he's being oppressive. There are certain oppressive behaviors that the courts have considered, and we can go into that one day in detail, but it's just for something, it's just something for you guys to keep in mind, that if you're being bullied by your fellow shareholder and it's simply not fair in your mind, consider approaching someone to have a conversation around section 163. Section 164 is a nice little section. So what happens there is minority shareholders can at a point, if there's certain decisions that are made, especially regarding their particular rights and with respect to their particular shares that impact them as shareholders, they can actually approach the court for the their shares and basically being bought out by this company. So that's a really nice mechanism for minority shareholders that want out, because they simply cannot vote, they cannot make decisions, and certain decisions are being made that impact them. Also something worth considering. So yeah, those are two sections in the legislation for those of you that are in bad businesses and might need to explore some options.
Great, thank you. And